Hello friends, in the series on the income tax cases, today we will discuss a case which is based on section 32. As all we know that in section 32, if an asset is purchased in a year and the period is less than 180 days, then the depreciation is allowed to the assessee for half and not for the full. The wording used in section 32 is put to use. Now, what should be the meaning of put to use if the asset has been purchased and only because of some formality the assessee is not able to use it commercially, but all the integrities have been fulfilled, and if to use that asset some certificate is obtained after 30th September, then whether in that case the depreciation should be provided for the full year or the depreciation should be provided to the 50%. This was the issue which has been taken by Delhi ITAT in the case of India Flysafe Aviation Ltd versus Deputy Commissioner of Income Tax. This case has been reported in 119 ITR Tribunal at page number 121, and the date of the judgment is 12th January 2024. The facts of the case are very interesting. In the present case, the assessee is in the business of providing aircraft on charter basis to various VVIPs, state government, corporate houses and travel agents. The assessee acquired an aircraft in July 2012 and a ferry flight was arranged with insurance cover from the new insurance company on 6th August 2012. An invoice was also raised for which the payment was made for the ferry flight, and this invoice was covering various expenses like pilot fees, etc. from the period 5th August to 7th August 2012. The assessee obtained the certificate of airworthiness from the Director General of Aviation on 21st September 2012, and this certificate was eligible from the date 18th October 2012 to 17th October 2015. When the assessing officer saw this certificate, the assessing officer was of the considered view that since this certificate is applicable from 17th October, so the assessee is using this asset less than 180 days, so the assessee is eligible to 50% depreciation. So he accordingly restricted the allowability of the depreciation under section 32 up to the 50% of the eligible rate, that was 40% in the present case. The assessee filed CIT appeal, but the CIT appeal also of the view of the assessing officer, and he upheld the additions made by the assessing officer in the form of reduced depreciation. So when the matter travelled to the tribunal said that in the present case there is no denying the fact that the assessee is a de facto and de jure owner of the aircraft. The tribunal also said that there is also no doubt that before the certificate of airworthiness from the Director General of Aviation, the assessee cannot take the passengers or the cargo, and since this certificate has not been obtained by the assessee from the ministry, it cannot be said that the assessee cannot hold the asset in its name. The tribunal also said that the obtaining of the certificate from the Director General of Aviation is only for the statutory compliance and to avoid any legal complexity, so it cannot be said that the asset is not put to use for the business purposes, and the tribunal said that the wording used in section 32 cannot be interpreted in a sense that it should be used for generating the revenue. Sometimes it may happen that the assessee has acquired the asset, has put the asset to use, but because of some certificate it is not able to use that asset. So in that case it cannot be said that the depreciation will be allowed from the date when the certificate will be operational. And the tribunal also said that since in the present case all the expenses relating to the aircraft has been allowed to the assessee, So the depreciation cannot be disallowed to the assessee. At the end of this video, once again I am repeating the name of the case. The name of the case is India Flysafe Aviation Limited versus Deputy Commissioner of Income Tax, and this case has been reported in 119 ITR Tribunal at page number 121, and the matter has been decided by Delhi ITAT, and the date of the judgment is 12th January 2024.